Okay.
Thanks for having the background. It looks very nice.
Sambil kita tunggu ya, Pak Farid.
Boleh.
Ada dosen juga yang join. Ya.
Oh. Morning, Dr. Sriwayu.
Dr. Sriwayu.
Morning, Dr. Farid.
Morning.
Nice to see you.
Nice to see you too, virtually.
Hi, great. Thank you very much for your time today.
Sure. It is my pleasure. How's your weekend? Are you all at the faculty or at home?
The faculty right now.
Oh, okay. Working on Saturday, is it?
Yes.
How's the weather in Purwokerto? Is it raining?
No.
Shining. Yes.
It was raining heavily here last night, so it's just very bright today.
We'll greet Bu Sri Hartini. Selamat pagi, Pak Kadar. Selamat pagi. They are the lecturer from Faculty of Law, Dr. Farid.
All right. Good morning, everyone. Nice meeting you all here.
Yeah. Good morning. Selamat pagi, Pak Supri.
Selamat pagi. So sore is petang, is it? Okay.
Yes.
Petang.
Sore petang, yes. Sore petang. Pagi is morning.
So pagi sama lah Malaysia dengan Indonesia.
Oh yeah.
Okay. So sore is petang. I visited Malang and Surabaya before, but it was back then in 2006, if I'm not mistaken. That was my first and last time I visited Indonesia. Never get any chance to go and see Indonesia. Yeah.
Go to consult Dr. Farid.
Nice.
Next year.
When I went to Surabaya, so I tried this drink. It's called
From Jakarta.
The yellow one now. This what is it called? It's a jamu. Airnya jamu.
Jamu. Traditional drink from Indonesia?
Yeah, no, in Indonesia. Beras kencur.
Beras kencur, yeah. Traditional drink from Indonesia, beras kencur.
And I was sweating after that. And I realized that it was jamu.
What's your favorite food from Indonesia?
Yeah, I like it so much. And that there's one keropok, so they fry it with sands.
Oh yeah.
Yeah.
In Jawa Timur.
Yeah. And nasi ayam penyet bakar, so I like it. So when I went
from Padang, rendang.
Yeah, rendang. Yeah. So when I went to Malang, so I saw Chris Dayanti's house, so huge.
Very famous in Indonesia and also in Malaysia.
Yeah. So Dr. Wahyu, so are you teaching public international law as well at the faculty?
Yeah, but I'm teach agrarian law.
Sorry?
Agrarian law.
Okay.
Yeah, my subject is agrarian law.
So your PhD is on?
Pardon?
Your area of research is on?
PhD, yeah. I'm from Faculty of Law, Universitas Indonesia.
Right. So your area is on arbitration as well.
in agrarian law. My area in agrarian law. Yeah.
Okay.
I graduated in 2021 last year.
Oh, okay. Congratulations.
Thank you.
Must be, you know, you must feel so great, you know, to finish your PhD, right?
Alhamdulillah.
I got mine in 2018.
Mhm.
Selamat pagi semuanya. Assalamualaikum warahmatullahi wabarakatuh. Nanti kita akan memulai acara ini sambil menunggu Pak Dr. Teddy Sudrajat ya. Good
Terima
morning
kasih.
everyone. Okay, we will opening session with Dr. Teddy. Okay.
Thank you.
Because Dr. Tadi, he is our vice dean, and we'll open this event today, Dr. Farid. So we're still waiting for him right now.
It is an honor to have all the docents, all the lecturers, faculty, and also the dean, you know, to be present on my last lecture with them.
Okay.
And I saw some familiar names here, Teguh and Natalie. So I think that they were my students last year. Is it, Dr. Ayuni?
Yes. I share
Natalie.
in Natalie class. Maybe Natalie
Hi,
join ya.
Natalie. Hi.
Yeah.
Hi,
Oh
Teguh.
iya.
Yeah.
Hi, nice to meet you again.
Good. We've been friends in Instagram, so we've been keeping in touch with each other since last year.
Assalamualaikum Bu Aryuni.
Waalaikumsalam Bu Tini.
Ye.
Ya.
Sudah
Ini-
tak umumkan tapi nggak tahu nanti mahasiswanya pada ikut nggak Mbak.
Terima kasih. Ini Bu
Ye.
Triwartini dari Universitas Islam Indonesia Yogyakarta, Pak Farid.
Ye.
Yogyakarta.
Belum pernah bertemu nggak kali Bu ini Bu Dr. Sri Wahyu.
Oh ya, selamat pagi Bu Artini.
Ye, selamat pagi.
Ye.
Kita pernah ketemu belum ya kita nggih?
Belum Ibu, kebetulan saya baru pulang sekolah tahun lalu,
gitu.
akhir tahun lalu, jadi baru bergabung ini di IUP.
Ye, jadi di mana Mbak kemarin dokternya?
Saya di UI Bu, Universitas Indonesia.
Ini nyon saya nggih, saya nggak on cam nggih.
Bukan apa-apa Ibu, terima kasih sudah bergabung.
Nggih. Ini sekarang IP-nya sudah mulai buka nggih? Tahun ini?
Sudah dari 2018, Mbak.
2018. Mahasiswanya banyak Mbak, seangkatan berapa?
Satu kelas itu sekitar 40 sampai 50 itu.
Oh gitu, nggih. Ya udah bagus lah, sekali buka udah dapat 40 50.
40-an 50.
Iya.
Sama ya Pak di UI?
Ya, UI kemarin 34 malah tahun ini 34. Nggih. Yang tahun sebelumnya itu sampai 80. Ini kemarin itu tinggal 34. Naik turun sih nggih.
pengumuman akreditasi internasional kapan, Pak?
Katanya
Sudah visitasi ya?
Juni ya. Oh, katanya sih Juni udah
Juni.
visitasi ya. Nih, Assalamualaikum, Dr. Farid. Bisa bahasa Indonesia tidak, Pak Dr. Farid?
Waalaikumsalam. Bisa Ibu, bisa.
Oh, bisa, ya.
Ya,
Dari San Universitas Islam Malaysia.
Iya Ibu. Saya pensyarah dosen di pensyarah di Universiti Sains Islam Malaysia.
Itu tuh tepatnya di kota mana ya, Pak ya?
Di Nilai, di Negeri
Oh,
Semilai.
dinilai.
So dekat saja dengan KLIA. Dengan airport.
Saya dari ini IIUM dulu, Pak.
Oh ya. Ibu belajar di IIUM.
Iya.
Bila tu, Bu?
Di tahun 2008.
Oh, 2008.
2008
saya masih ijazah masa itu.
Gitu. Saya lulus 2012.
Oke.
Ya.
Siapa supervisornya, Bu?
Supervisornya Prof. Hasib Ansyari.
Oh, Prof. Hasib.
Iya,
Evidence
karena
ke,
ambil
Bu?
lingkungan.
Lingkungan.
Iya. Sama ini co-supervisor Dr. Mo Hisham.
Dr. Hisham.
Ya, sekarang sudah profesor belum ya, Dr. Hisham?
Belum lagi, dia masih associate professor.
Oke.
Kami kenal dan rapat masa JESAP.
Oh, JESAP, Moodcourt Competition ya?
Ya, JESAP. Dr. Hisham coach JESAP.
Coach JESAP.
Coach JESAP di IIU.
Oke.
Iya.
Sama Dr. Iqbal kenal?
Dr. Iqbal ya. Saya buat master di IIU.
Oh, kalau master di IIU mesti kenal semuanya.
Ya. Saya mengajar part time tutor di IIU. Saya ajar TOTS dengan land law.
Oke.
Ya, selamat datang Pak Teddy Sudrajat. Ini Pak Wakil Dekan sudah hadir.
Selamat datang Pak Teddy. How are you?
Fine. Selamat datang Pak Farid, Bu Wartini juga.
Iya. Pak Teddy, ini kita seling komunikasi ya Pak.
Iya ini.
You look dashing, Pak Teddy, with your batik. You know, I like the leaves.
Colorful batik.
Iya. Alhamdulillah sehat-sehat semua ya.
Alhamdulillah ya.
Hari ini jalan ke mana Pak Teddy? Hari ini Sabtu weekend.
Waduh, nah itu dia. Weekendnya harusnya keluar, tapi ternyata ada sesuatu yang harus dikerjakan. Jadi ya, di hold dulu liburannya.
Ya, kita kerja sebagai pensyarah ni, hari cuti pun kerja.
Kerjaan tidak ada habisnya.
Iya, betul.
Okay, well, ladies and gentlemen, may I have your attention, please? Yeah, our session is about to begin. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning. Welcome to the General Lecture, Faculty of Law, Jenderal Sudirman University. With the theme of International Dispute Settlement, I'm Eni Dujahani, your Master of Ceremony for today. I also would like to greet one, the Honorable Dr. Teddy Sudrajat SHMH, Vice Dean Faculty of Law, Jenderal Sudirman University. 2, the Honorable Dr. Aryuni, the Coordinator of International Undergraduate Program, Jenderal Sudirman University. 3, the Honorable Dr. Farid Mohassan, a lecturer at Sharia and Law Faculty of Islamic Science, University of Malaysia, as the keynote speaker. 5, the Honorable Dr. Sri Wahyu Handayani SHMH, a lecturer at Law Faculty Jenderal Sudirman University, as the moderator. And 6, the distinguished students of Unsud and USIM. First of all, let's praise to the Almighty Allah Subhanahu wa Ta'ala. Because of His blessing, we are able to attend this event. Secondly, may peace be upon the Prophet Muhammad Sallallahu Alaihi Wasallam, who has guided us from the darkness to brightness. Ladies and gentlemen, please allow me first to read the agenda for today. The first agenda is the opening session. Second is speeches. Third, general lecture and discussion session. And the last is closing. Ladies and gentlemen, we are now in the opening session. Let's begin this event by saying basmalah together. Bismillahirrahmanirrahim. Hopefully, by starting this event with basmalah, this event can run smoothly as it should. Without further ado, I would like to invite on the coordinator of International Undergraduate Program, Jenderal Sudirman University, Dr. Aryuni. The floor is yours.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Greeting to all of us. The Honorable Dr. Deti Sudrajat, SHMH as Vice Dean in Academic Field, the Faculty of Law, Universitas Jenderal Sudirman. The Honorable Dr. Farid from University Sains Islam Malaysia, and all participants. Before starting the general lecture, I, as coordinator IUP, will report about this activity. Visiting lecture or guest lecture is a part of the IUP program that holds in every semester. In this semester, we have two guest lectures. The first, Dr. Haning Kamarudin from University Kebangsaan Malaysia, who teaches in the environmental law, and Dr. Farid, who teaches public international law from UMUM. The general lecture is aimed to spread knowledge more broadly for students, not only from Faculty of Law, UNSUD, but also from other universities. The participants in this general lecture are from UNSUD, UMUM, Universitas Teknologi Malaysia, Universitas Sultan Syarif Brunei, Universitas Zainal Abidin, and from UUI. Maybe. I hope we all get knowledge more from this activity. And I hope the IUP students can get international point as requirement graduation. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Aryuni. Ladies and gentlemen, I would like to invite the Vice of Dean for delivering the next speech on and officially opening the general lecture. Dr. Teddy Sudrajat, time is yours.
Yeah, thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be to the peace and God blessing be to you all. Good morning for everyone. Our respected Dr. Aryuni Yulianti Ningsih, SHMH, Coordinator of International Undergraduate Program, Faculty of Law, Universitas Jenderal Sudirman. Thank you for organizing these academic activities. This is an interesting matters and must be continued to be implemented to improve the academic atmosphere at UNSUD. And our respected Dr. Farid Muhammad Hasan from Faculty of Syariah and Law, University Sains Islam Malaysia. Thank you, Dr. Farid, for taking the time to attend these general lectures. And it is an honor for us to have you here as speaker. And I really hope that next time you can come directly to Purwokerto and you will feel the learning atmosphere at UNSUD, and we will waiting for you here. And our respected moderator and all of the students and all participants. First of all, praise to be Allah who has given us a good health so that we can gather at this event. Also blessing to our Prophet Muhammad SAW. And second of all, thank you to each and every one of you for being here today. And it is an honor for me to speak on behalf of the faculty. And let me begin by giving you a warm welcome to this general lecture, which is held by International Undergraduate Program, Faculty of Law, Universitas Jenderal Sudirman. Before we get started, I'd like to express again my appreciations to International Undergraduate Program, and also for the committee who held these general lectures, and also for the speakers. And we will discuss an interesting issue in these general lectures. We'll discuss about the international dispute settlement. And nowadays, international disputes are a problem that often arise, and we can deny that conditions, and we have to solve that conditions. So this matter, it's interesting thing to study and discuss, and hopefully that we will have a fruitful discussions. So in this occasion, we invite Dr. Farid Muhammad Hassan for providing us to give us a complete pictures regarding this issue, and hopefully we can have a lot of insight to solve these problems, and we will have a lot of material to be discussed in the next issue. Finally, to following the committee request by saying Bismillahirrahmanirrahim, today on Saturday, 4th of June 2022, I officially opened these general lectures, International Dispute Settlement, and hopefully this activity can provide benefit for all. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Teddy Sudrajat. Ladies and gentlemen, I respectfully request all attendees to turn on the camera so that we can take photos together with the help of screenshot by our operator. Because there are so many attendees, then there will be about 4 to 5 times of picture taking. Please get ready. Here we go. 1, 2, 3. Keep smiling, everyone. Yeah, here is the next screen. Next shot. Okay, done. Thank you so much. Ladies and gentlemen, now we have come to our main agenda, the general lecture session. All presentation and discussion will be moderated by our moderator, Dr. Sri Wahyu Handayani, SHMH. Allow me to read her short biography. Dr. Sri Wahyu Handayani, SHMH, completed her bachelor's and master's studies at the Faculty of Law Jenderal Sudirman University and doctoral program at the Faculty of Law University of Indonesia. She is a lecturer and also the chief of the law laboratory at the Faculty of Law Jenderal Sudirman University. Ladies and gentlemen, let's welcome our moderator, Dr. Sri Wahyu Handayani, SHMH. Ibu Ayu, the floor is yours.
Miss Annie. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Dr. Teddy Sudrajat as Vice Dean, Faculty of Law, Jenderal Sudirman University. The Honorable Invited Speaker, Dr. Farid Muhammad Hassan from Faculty Syariah and Law, University of Science Islam Malaysia. The respected guests and all the audience. Good morning, everybody. It's my pleasure to welcome everyone to the general lecture with the theme International Dispute Settlement, and this event held by Faculty of Law, Jenderal Sudirman University. Yeah, and before we begin, I would like to greet all the audience who kindly get to us through Zoom. And I see here in registration form, many students come from University of Science Malaysia, University Sultan Zainal Abidin, Kuala Terengganu, Malaysia, University Islam Sultan Syarif Al Brunei Darussalam. I'm truly grateful and delighted to have you all. And I'm Sri Wahyu Handayani as your moderator in this general lecture. Okay, firstly, let me remind that the participant audio will be mute and can be active in the Q&A session after the presentation from the speaker. And please turn on your camera along this event. And the participant can ask by raise hand or kindly type your question on the chat room, and I will read the question on the Q&A session. Okay, and now let's start this general lecture. Firstly, I will introduce Dr. Farid curriculum vitae. Okay, name Dr. Farid Muhammad Hassan, and who was born at May 13, 1986, and he has degree academic. He got Doctor of Philosophy and Law in 2018 with excellent, well, very great, from School of Law, University of Aberdeen, Scotland, United Kingdom. Congratulations, Dr. Farid. And Master of Comparative Laws from Ahmad Ibrahim KULIAH of Laos, International Islamic University, Malaysia. And Bachelor of Sharia and Law from Faculty of Sharia and Law, University Science Islam, Malaysia. And his area research are international criminal law, international criminal justice, international humanitarian law, law of treaties, public international law, and constitutional law. Southeast Asian countries. And he has work experience as guest lecturer in public and law, human rights seminars and University of Stirling, Scotland, UK, and visiting lecturer in University Sultan Zainal Abidin, Malaysia, and also ever become judge oral submission for the Philip J. Jessup International Law Court competition in 2021, and judge for the Philip J. Jessup International Court competition. And judge for the e-novice arbitration mooting competition in 2020. And he has a book entitled Statehood, a Legal Overview, Millennial Global Resources 2019, and also have many book chapters here and many publications in international journal. Okay, and good morning, Dr. Farid Muhammad Hassan.
Good morning, Good
Yeah.
morning, everyone. Thank you for your warm introduction.
Okay, and all that, ladies and gentlemen, today he will share his perspective on the various issues related to the international dispute settlement. As we know, ladies and gentlemen, international dispute settlement is a mechanism to resolve disagreement between two or more international parties, including sovereign parties and internationally active non-state parties, such as large corporations. There are a diverse set of techniques used in international dispute settlement, including negotiation, mediation, arbitration, and also adjudication. And how is the more explanation about that? Now, without further ado, please welcome Dr. Farid Muhammad Hassan will be presenting about international dispute settlement. Dr. Farid Muhammad Hassan, time is yours.
Right, thank you so much, Dr. Sri Wahyu. And first of all, before I begin my lecture, allow me to thank to the Faculty of Law of UNSUD for having me and for inviting me since last year as visiting lecturer and visiting professor. And also thank you, Dr. Teddy, Dr. Aryuni, Dr. Sri Wahyu, and also Dr. Sri Wartini, and all the lecturers of the Faculty of Law in Indonesia. And also all the participants from Malaysia, from USIM, from UNISA, and also our neighbor from Brunei Darussalam, for coming and spending your Saturday morning with us, hearing a heavy subject on public international law, particularly on international dispute settlement. Now, allow me to share my screen and allow me to share the slides of my presentation so that everyone would be able to follow my presentation very well. Is my screen visible?
Yes, you can see your screen.
Okay, thank you so much. So today is basically my fifth and last lecture, teaching public international law at the School of Law, UNSUD. I've been lecturing on the previous lecture on United Nations and also the Security Council, the use of force, international humanitarian law, and also we have discussed on state and also individual criminal responsibility. So out of all these discussions, then we come to the end of the conflict between parties to the disputes, whether it is states and also between individuals, which we talk about international crimes. So today's lecture, we discuss on dispute settlement. How would states and also individuals settle their disputes, right? To be investigated and also to be prosecuted for the crimes committed at the international level. And for the purpose of today's lecture, we will discuss on what are the issues, right? Because when we talk about dispute settlements between states and parties or between states and individuals, right? For civil and also criminal matters, right? Disputes will normally be brought to certain competent tribunals or courts in order for those parties to settle the disputes, right? But although in our mind, right, when we bring matters to courts, to tribunals, then we will have this kind of expectation that these disputes will be settled peacefully. Whatever the decisions made by the courts or made by the tribunals will be implemented, and all the processes, right, from the beginning of the trial or the beginning of the proceedings until the end of the proceedings, until the tribunal or the court has decided, has given their respective judgments and awards, then those awards and decisions will be implemented by states, right? However, it is not as beautiful as we all thought, right? When we talk about disputes at the international level, right? Because there are requirements and also issues on dispute settlements, which I would like to highlight, right, in this lecture, right? I will not be explaining on what are the types of dispute settlement mechanisms that are available at the international level. Rather, then I would like to talk about what are the issues, right, when parties, whether states or individuals, are bringing matters before the court or before the tribunal at the international level to settle their disputes, right? So we will see and discuss on three issues at the international level. First, on the issue of state sovereignty. Second, on the issue of immunity. And lastly, on the issue of state cooperation, right? So I will discuss and explain all these three points in turn. Now, generally, right, there are many ways when we talk about dispute settlement, right, at the international level. Parties normally seek to or decided to bring matters to different kind of dispute settlement mechanisms, right, such as arbitrations, right, to court, or using politics, right, or by way of political means, right, between states. And also some disputes will be using the General Assembly of the United Nations and also the Security Council to the United Nations to settle international disputes. And some will resort to mediations and conciliations. But whatever dispute settlement mechanisms that the state decided to use, right? So all these will lead to settling disputes between parties. So among all these dispute settlement mechanisms, arbitration is and has been among the earliest dispute settlement mechanism that has been used by states for many years, right? Then courts or international tribunals have been developed after the end of the First World War. So for the purpose of today's lecture, I will only talk briefly on arbitrations and also courts and also tribunals at the international level, rather than to go through all these other dispute mechanisms. Now, So the first and among the earliest dispute settlement mechanism at the international level is arbitration, where interstate arbitration is actually had long been practiced by states, right? Where, you know, since it started, you know, many procedures have been updated, have been beautified by parties or by states when settling their disputes, right? To be similar to judicial settlement, right? As we all know that arbitration has flexibility in terms of procedures, right? In terms of the sittings of the courts and the discussions between the parties, right? Which become the reason why states particularly to resort or to use this dispute settlement mechanism at the international level. So the starting point of the increasing number of the successful of the use of arbitration at the international level was started after the case of Alabama claim arbitrations between the US and also the UK in 1872. So I would like to briefly explain what had happened in this case, right? So that we will be able to appreciate, right, on the dispute settlement between these parties. Now, in the case of Alabama claims arbitration, right, so or the full name of this case was Alabama Claims of the United States of America against Great Britain, which was decided by the Arbitral Tribunal in 1872. Now, what happened in this case was on the interpretation, on the issue of the interpretation of Article 6 of the Treaty of Washington entered into between parties, right? So those states who have ratified and acceded to this treaty, among others, are the US and also the UK. Now, what happened in this case was that Article 6 mentioned that all state parties to the Treaty of Washington must uphold the principle of neutrality, where they cannot interfere with another state's internal matters. Right? They cannot intervene and do anything which would affect the other state's sovereignty and so on. Right? Particularly not to construct or not to equip or not to armament of a vessel, right? Because at that time, states have been resorting to wars, and piracy have become one of the ways, right, of settling disputes, of taking over or winning the disputes among states at that time. So what happened in this case was that the UK built a number of vessels, right, to a private buyer, right? So one of those vessels or one of those ships were named as the Alabama, right? So all these ships, including the Alabama, have been constructed by the UK, right, and sent to the buyer. So these ships were all unarmed, right? There were no shotguns or whatever at that time, right? So that all these weapons to be used for battles, right? So when it left the UK at that time, so the ships were all clean, right, without any armaments, right? But later on, those ships were fitted as warships, and these ships have been transformed to become warships, right? Then these ships have been used to attack a number of Union merchant ships belonging to the US, right? Right, during the American Civil War in that year. Now, when the ships, the US merchant ships have been attacked by all these ships built by the UK, right? So the US demanded a number of damages, right? A series of damages. So the US would like to claim for monetary compensation because the UK did not fulfill its obligation under Article 6 of the Treaty of Washington, right, by constructing and arming the ships, right? So it has breached its obligation of neutrality at the time. So the UK argued at the time that it is very difficult for the UK to be neutral because of the demand by the private buyer. So if there were demands by the buyers, so the UK has the obligation to construct and to build those ships, right? So when the case had been brought to the tribunal, right, to the arbitration at that time, so the arbitral tribunal at that time held that the UK was responsible and must pay compensations of 15.5 million US dollars to the US, right, for its breach of obligation of neutrality at the time. So when this case was won by the US, that was a certain point where arbitration has been used by states later on, right, to bring matters to the arbitration, right? So now, when years after years, right, when arbitration has been used and so on, then catastrophic events took place, right, at the international level, where the First World War and the Second World War took place, right? So two World War wars, right? Although these World War wars had contributed to catastrophic events to many parts of the world, right? But there would always be good things happen out of those catastrophic events, where right after the end of the First and Second World War, then two international organizations have been established, right, by the international community. First, called the League of Nations. Second, the United Nations that we have nowadays, right? So the purpose of these organizations, the League of Nations and also the United Nations, were to prevent future wars and also to maintain international peace and security. Now, I would like to talk about the First World War, right? So because when we talk about law, when we discuss about law, we cannot run away from discussing and talking about history, right? Because we learn from history and we pass law, we enact new law so that whatever happened before would not be happening again in the future, right? Because of the historical events that took place previously. The same goes to the First World War at the time. Now, the First World War took place between the Allied and Associated powers of the British Empire, the US, France, Japan, and also Italy, known as the Allied powers against the Central powers of German Empire, Ottoman Empire, Austria-Hungary, and also Bulgaria. After the end of the First World War, then the League of Nations was established. And apart from the League of Nations, then there is one international court which was also established together with the League of Nations, called the Permanent Court of International Justice, or in short, we call it as PCIJ. Right? So basically, the League of Nations was the predecessor to the United Nations. Right? Before we have the United Nations, now we had the League of Nations. Right? So the League of Nations was established through the Versailles Peace Treaty, or VPT, in 1919, right, between the Allied powers of the World War at the end of the First World War. So the aim of the League of Nations was established is to maintain world peace, and parties and states at that time, they pledged, right? They have sworn, so they have taken an oath that there will be no future war, right? To take place, right? But as we all know, that Second World War took place, right? Although the League of Nations failed, right, to prevent the Second World War, but at least, efforts have been put by the international community to stop the war, right? So out of this is the pictures, right, taken from the website where and how the League of Nations was convened at that time. So this was akin to the General Assembly of the United Nations at the time, right, where states or representative of states came together and discussed on international matters, right? Now, the PCIJ. Now, basically, the PCIJ was formed or established as a judicial dispute settlement out of the League of Nations through or by virtue of Article 13 and 14 of the League of Nations Charter, right? Whereby Article 13 of the Charter of the League of Nations mentions that the PCIJ would be established, right, pursuant to Article 14, right, in order to settle disputes, right, particularly on any interpretations on any conventions among the states at the time, right? So Article 14 also mentioned the same, where the PCIJ would have the international character and may have jurisdiction to hear and determine cases on disputes between states, and also may provide advisory opinion, right, if necessary, right? So after the PCIJ was established, right, so many cases have been brought, right, to the PCIJ, right, so that the PCIJ to interpret whether states have breached its obligation or their respective obligations arising from the treaty, right, which they have entered into, right, before the disputes arose. So one of the cases was in the case of exchange of Greek and Turkish populations in 1925, which was brought before the PCIJ at the time. So I would like to explain briefly on what happened basically in this case. Now, in this case, the Greek and also the Turkish government entered into a treaty called the Lausanne Convention or the Lausanne Treaty, right? So among the provisions or among the obligations arising from this treaty, from the Lausanne Treaty, was that the Orthodox Christians arrested and taken into custody by the Turkish government must be released, right, so that they can be released, and those detainees can go back to Greece, right, where they came from. And also those Muslims which have been captured and arrested by the Greek government to be released, and also to go back to Turkey at the time. So there would be an exchange of detainees, right, between the Greek and also the Turkish governments. So that was the obligations out of the Lausanne Convention between the parties, right? So it involved millions of detainees, right? You can see on the screen where and how many population that were supposed to be transferred between the Greece and also the Turkish government. However, both parties, right, decided, or refused to extradite those detainees. Then the case was brought up to the attention of the PCIJ, where the parties, right, the Turkish and Greek government have breached their obligation under the Lausanne Convention to exchange the detainees, right? So the PCIJ was of the opinion at the time that, when states have entered into treaties between them, they must fulfill their obligations, right? So when states did not fulfill their obligations, then, they have breached the treaty, right? So this was the interpretation provided by the PCIJ at that time, and the decision from this court has become customary international law and incorporated under the current Vienna Convention on the Law of Treaties, under the principle of acta sunt servanda and so on, under Article 26 and 27 of the Vienna Convention, and has been applied by the states as customary international law. So this was the photos which reflect the last session of the PCIJ before the Second World War took place, right? So having finished with the event of the First World War, where the PCIJ was established, then the Second World War took place in 1939 until 1945 between the Allied forces of the UK, the US, France, and also the Soviet against the Axis forces of Nazi Germany, Italy, and also the Japanese Empire. Right. So this just to refresh our minds on what had happened previously on the Second World War. Now, after the end of the Second World War, then another international organization was established, that is the United Nations, that we have until today. So out of the UN, then the ICJ, or the International Court of Justice, has been established, right, from the UN Charter. Let's briefly go on what is the UN and what are the organs of the UN. Then we will go to the discussion on the ICJ. So it was founded, the UN was founded in 1945, right after the end of the Second World War. So currently the UN has 193 members, right? So all states in the world are parties to the UN, right? Only some states have not yet become parties to the UN, but we will not talk about that for the purpose of this lecture. So as I explained earlier, that the purpose and object of the UN, and also the same goes to the League of Nations, was to stop the scourge of war, and also to respect justice and also respect obligations arising out of treaties entered into by parties. So this is just a reflection of the UN building, right? So 193 members are parties to the UN and also parties to the UN Charter. So among the provisions under the UN Charter are Article 1 and Article 2, which talk about the maintenance of international peace and security, and how aggression, right, is prohibited under international law. So that when aggression is prohibited under international law, then disputes between parties would be settled peacefully, right? So this in conformity with the principles of justice and international law, because if parties are still quarreling, then disputes cannot be settled, right? So that is why international law prohibits the aggression at the beginning, right? So that whatever grievances occurred between parties would be settled peacefully by the parties. So these are among the excerpts from the provisions of the UN Charter. But I would like to highlight on Article 2, Clause 3 of the UN Charter, where it mentions clearly that all members, all UN members, shall settle their international disputes by peaceful means, right? So that peace and security and justice are not endangered, right? So the use of force are prohibited under Article 2, Clause 4 of the UN Charter, right? So that is the main provision where state parties to the UN, particularly all states in the world, must settle the disputes without using any force, right? Because to solve international disputes, cannot be settled by way of force, right? So must be settled peacefully. So when we talk about international dispute settlements, we talk about, and the parties must involve states, right? Normally, right? Rather than individuals, right? We will go one by one, where states become parties to international dispute settlements. And later on, we will see how individuals become parties to international dispute settlements, right? Now, under Article 70, Clause 1 of the UN Charter, it talks about the organs of the UN. So one of the organs of the UN is the ICJ, the International Court of Justice, as stipulated under Article 7, Clause 1 of the UN Charter. Now, these are among the excerpts, right, taken from the ICJ statute and also from the UN Charter, right? So Article 92 of the UN Charter establishes the ICJ under Chapter 16 of the UN Charter, where it states that the ICJ or the International Court of Justice shall be the principal judicial organ of the UN, right? So there will be none other judicial organ of the United Nations rather than the ICJ, right? So Article 93 mentions that whosoever member states to the UN will be automatically become parties and members to the ICJ, right? So if we have 193 state parties to the UN, so all these 193 states are automatically parties to the ICJ statute. So Article 36 of the ICJ statute mentions on the jurisdiction of the ICJ. So what are the jurisdiction of the ICJ? So the jurisdiction of the ICJ is on all matters except for criminal matters. So the jurisdiction of the ICJ, right, is on the interpretation of a treaty, as has been highlighted under Article 36, right, the interpretation of a treaty. Any questions of international law, whether states have breached its jus cogens obligations of customary international law obligations and so on, right? Whether whatever acts or omissions which have done by states constitute breach of international obligations, and also whatever reparations or damages to be claimed by the parties. So all these will fall under the ICJ jurisdiction, right? So Article 37 of the ICJ mentions that, because remember previously we had PCIJ. So whether the ICJ is the successor to the PCIJ, the answer is yes. So it has been mentioned clearly under Article 37, where the ICJ would continue the works of the PCIJ. And whatever jurisprudence or decisions decided by the PCIJ would be of assistance to the ICJ to decide on international law matters. Okay. Now, finish with the establishment of the international dispute settlement mechanism of the ICJ at the international level, right? Then parties would bring matters or disputes arising out of the treaty, where the states have breached their treaty obligations or international law obligations, right? Which has been practiced for years under customary international law, and whatever damages or reparation to be claimed by states would be brought before the ICJ. But when parties bring the case to the ICJ, right, or before the parties bring the matters to the ICJ, then many issues or many principles of international law must be observed by states, right, at the beginning until the end of the process. So one of the issue is on the issue of the principle of state sovereignty, right, kedaulatan negara, all right, in bahasa. Now, I would like to delve into the details of the issue of state sovereignty, right? So we have to go to the crux or the core principle of international law on state sovereignty, right? So that we would be able to understand why state sovereignty really matters when we talk about dispute settlement mechanism at the international level. First, on the competence of the ICJ jurisdiction, right? What is the basis, the foundation of the ICJ jurisdiction at the international level, right? First is under Article 34, where it mentions clearly that only states would become parties to any case before the ICJ, right? Any individuals, any corporations, right? Non-state actors will not have competency to appear before the ICJ except for states, right? So only the ICJ will only hear cases between states, right? But when we talk about states would be the only parties to the ICJ, so it means that states themselves must agree to bring the disputes to the ICJ, right? So if both states or more states, or more, if two or more states have agreed to bring the matters to be settled by the ICJ, then it will be the compromise of those states, right? Because under Article 40 of the ICJ, my apologies, of the ICJ statute mentions that, you know, notification of special agreement, right, agreed between states must be submitted to the ICJ before the ICJ to exercise jurisdiction, right? Or else the ICJ would have no competency to hear cases, right? Let's say if two parties, let's say state A and state B, or even, for example, Malaysia and Indonesia, we have disputes, right, arising out of the treaty or on international law. Both Malaysia and Indonesia must agree to bring the matter or to bring the case to the ICJ. It cannot be an ex parte application or one party only to be brought to the ICJ, right? Because it will not become compromise, right? So it will not fulfill Article 40 of the ICJ statute. So both states must agree, must sign an agreement that, you know, the disputes between them, between Malaysia and Indonesia, shall be decided by the ICJ, right? So the parties involved must agree, right, to be decided by the ICJ. So in this situation, states cannot decide cases or disputes dealing among them nationally, all right? Because decisions of domestic courts cannot be implemented, cannot be enforced at the international level, all right? And whatever decisions, for example, let's say there is a dispute on international law between Malaysia and Indonesia, for example. So the Indonesian court or the Malaysian court cannot decide whether Indonesia has breached its obligation or whether Malaysia has breached its obligation arising out of the treaty, right? Why? Because it whatever decisions to be made by the Indonesian or Malaysian courts will not bind each other, right? If Malaysian court decides or decided on against Indonesia, then the decisions from Malaysian court cannot be enforced, cannot bind Indonesia. Why? Because of the issue of state immunity under international law. Because of the issue of state sovereignty. I will explain to all of you what is state sovereignty, what is state immunity under international law. Now, there is a principle under international law dealing with state immunity and state sovereignty, which is called par imparem non habet imperium, right? So this is a Latin word, right? A Latin principle, where one state is equal to another, regardless of the size. For example, if we compare Russia as the biggest country on earth, if we compare with Timor-Leste or with Singapore, for example, or with Fiji, for example. So regardless of the size, in the eyes of international law, these states are equal, right? Regardless of the population, how rich is that country, how big is that country, how big is the population of that country, that will not be taken into consideration. One state will not be superior over the other states under the principle of par imparem non habet imperium. So if states are equal under international law, then one state cannot decide on the matter against another state. Okay, that this is principle under international law. All right, so in the eyes of international law, all states will be at the horizontal level where they are all equal, right? So when we talk about state immunity, we talk about state sovereignty under the principle of par imparem non habet imperium, where, for example, Malaysia cannot decide on Indonesia. Indonesia cannot give judgment on Malaysia, right? Because Malaysia and Indonesia are equal, right? So in order for Malaysia or Indonesia to settle, right, our respective disputes, then it must be decided or it must be judged by an entity or by an organization which is higher than a state. Okay, because, you know, an equal cannot decide on another equal, so it must be decided by another party, another organization which is higher than a state, right? only then whatever decisions to be decided by this higher level organization will bind either states, right? When the decisions have been made, okay? So if this happened, then the principle of power imperatives non-habit or state sovereignty will not be violated, because state sovereignty or state immunity is customary international law. This is general international law that cannot be violated by any states in the world. So I would like to highlight one of the decisions of the ICJ pertaining to the issue of state sovereignty, which was decided very recently in 2012, right, between Germany against Italy, where Greece intervened in the proceeding in the case. The name of the case was jurisdictional immunities of the state, right? Now, what happened in this case was, when the Second World War took place, the German Nazis committed international crimes, torture, war crimes, crime against humanity, and so on, all right, against civilians. Okay. Now, when Second World War had been put to an end, right? So the victims, right, of the Second World War brought or file a case, right, before an Italian courts and also before the courts in Greece, right, to claim reparations, to claim monetary compensations against Germany, right, because Nazi was the government or the authority of Germany during the Second World War, right? So these parties or these victims brought or filed claims or reparations against Germany, right, to claim monetary compensation against Germany for the crimes committed, right, on war crimes, torture, and so on, committed by the Third Reich during the Second World War, right? So there were cases in Italy, there were cases in Greece, right? So when the Greek civil courts decided, right, on a number of cases, particularly in the case of Distomo, all right, Distomo in Greece, where German Nazi had committed war crimes in Distomo village, right? So the victims in Distomo village claim monetary compensation or claim damages against Germany. So the Greek civil courts decided in favor of the victims. So this decision to be combined with the decisions of the Italian courts, so that the Italian courts would enforce the decisions of the Greek civil courts and to be given to the respective victims who also been living in Italy at a time. Okay, so when the Greek and also the Italian courts decided that Germany was responsible, Germany must pay compensation to all the victims. So Germany brought the case against Italy on the ground that Italy had violated Germany's sovereignty under international law, that Italy had violated Germany immunity under international law, because when the Italian courts decided that Germany was responsible, Germany was liable and must pay compensation. So Italy had decided on the fate of Germany. So this is a violation of state immunity. So this was the argument advanced by Germany. So when Germany filed case against Italy on the violation of customary international law on state sovereignty, Greece also filed an application to intervene in the case, because one of the cases filed against Italy by Germany was on this Distomo case, where the decision of the Greek civil courts was to be endorsed by the Italian courts. Right, so Greece was one of the parties in the case. Now, when the case was decided by the ICJ decided that Italy was wrong. Italy was or had breached international law by ignoring Germany's immunity under international law, because Italy cannot decide on the fate of Germany, right? Because it has violated par imperium non habet imperium principle, right? Because Italy had decided on the fate of Germany. It cannot be done so by Italy under international law, right? So when Italy argued that, you know, the crimes committed by German Nazis at that time were violations of jus cogens, violations of customary international law, the ICJ held that the violations committed by Germany was another issue, right? The issue to be settled by the court in this case, whether Italy had breached its customary international law for violating immunity of Germany at that time, and the answer was to be given on the issue of immunity of Germany, whether it has been violated by Italy or not, rather than disposing the issue of jus cogens violations committed by Germany at the time, right? So the decisions of the ICJ was given to Germany that immunity and sovereignty of Germany must be upheld, must be respected by Italy, and cannot be breached. So whatever decisions made by the Italian court must be set aside, right? Whatever decisions to be enforced must be stopped, right? Because of the violation of par imperium non habet imperium principle. Okay. Now, so when parties, right, agreed to bring the case, right, or agreed to bring the dispute between them to the ICJ, for example, those decisions will be binding. All right, this was spelled out under Article 59 of the ICJ statute. All right, so the same goes to the decision of the ICJ between Germany and Italy just now. Since Germany and Italy agreed to bring the case to the ICJ, then whatever decisions made by the ICJ would be binding, and Italy must enforce the decision of the ICJ. Okay. Now, not only agreement of the parties, right, persetujuan or agreement by the parties must be attained at the beginning, so that state would settle the disputes among them, right? My apologies for the noise side, because like they are cutting off the grass, right, at the back of my office. Now, similar to other proceedings on arbitration, on mediations, on whatever dispute settlements, all parties must agree to bring the matters to whatever dispute mechanisms at the international level. Why? Because whatever decisions to be made, then it will bind all the parties. Okay, this had happened, right? In the case of arbitration on the issue of South China Sea arbitration decision between the Philippines and also China, where China was not a party to the arbitration proceedings, right? And the Philippines was the only party to bring the matter to the Permanent Court of Arbitration. Now, if you look here, China adopted a position of non-acceptance and non-participation in the proceedings. It means that China did not agree to bring the case to the arbitration, right? The only party to this case was the Philippines. So when the arbitral tribunal, in this case the PCA, the Permanent Court of Arbitration, decided that China had violated international law so and so and so, then the decision cannot be enforced. The decision of the arbitration, in this case, cannot bind China, right? So that is why China refused to implement the decision of the arbitration center or the PCA in this matter, because China at the beginning did not accept the jurisdiction of the PCA and did not participate in the proceedings, right? So whatever decisions made by the PCA at the time cannot be enforced because China was not a party to the proceedings at the beginning. So it does not only apply to courts or tribunals, but also it applies to whatever mechanisms, right? It cannot be done on ex parte application, right? In contrast to domestic application, where in national courts, if a legal suit has not been responded by another party, then the court may decide based on judgment in default, for instance, right? For example, in Malaysia, if A sues B, if B does not respond to the legal suit, then A may apply to the court, right? And the court will apply, will decide based on judgment in default, because B did not respond to the legal suit, but not at the international level. Okay. Now, what if the decision of the ICJ has been done, right? Whether it can be appealed or not, the answer is yes or no, right? Now, the general rule is that whatever decisions made by the ICJ would be final, because there will be no appeal, because the ICJ is the only proceeding or the only hierarchy, right? There is no higher hierarchy other than the ICJ, right? Unlike in domestic courts, where we have appeal courts. At the international level, especially the ICJ, there is no appeal courts of the ICJ. Right, so whatever decisions made by the ICJ would be final and without any appeal. That is the general rule. There is one exception where parties, right, may revise the decision of the ICJ. It is not called appeal, but only revision of the decision, right? Under Article 61, it mentions that if parties to the case found out that there are facts, all right, or evidence which have been discovered and not disclosed during the proceedings between the earlier case, then the parties may seek for revisionary decisions of the ICJ, right? So, and this discovery of new facts or new evidence, right, cannot and shall not be at the ignorance of the parties, right? Or states have made negligence or have done any negligence, that they forgot or they refuse to highlight those facts or those evidence at the trial or at the proceedings, right? Only if they found that, oh, there are other facts, or there are other evidence, all right, that they just found out, only then the parties may seek for court's revisionary power to be exercised by the ICJ. And this revisionary power to be exercised by the ICJ must be made within 6 months after the discovery of the facts or the evidence, right? So after the expiry of that, then it will no longer be done. And application to revise to the ICJ must be made in 10 years' time after the date of judgment, right? Let's say the date of judgment of the ICJ was made in 1st January 2010. The last date of the application to revise the ICJ decision must be made before 1st January 2020, right? So it must be made within 10 years' time. After the lapse of 10 years' time, then revisionary jurisdiction of the ICJ will not be exercised by the court anymore, right? Because of the lapse of the time frame. Okay? Now, not only parties to the disputes may bring the case to the ICJ, but also the Security Council and also the General Assembly of the UN of the United Nations may also bring or request the ICJ to provide an advisory opinion, right? This was spelled out or has been spelled out under Article 96 of the ICJ stated, where the General Assembly and also the Security Council of the United Nations may request the ICJ to give an advisory opinion. Now, as compared to cases brought by states to the ICJ, advisory opinion, whatever opinion, all right, decisions, we call it advisory opinion of the ICJ, will not be binding, but will only be highly persuasive in nature, right? But this advisory opinion of the ICJ would be binding in the future if future cases brought before the ICJ adopts whatever advisory opinion given by the ICJ. Okay? So there are many cases which have been brought by either the General Assembly or by the Security Council to the ICJ for advisory opinion. If you find any names of the case, right, the ICJ case, and if you find the name of advisory opinion, right, in the case such as this, which is has been highlighted in the red color, it means that these are all advisory opinion, which is not binding, right? But it will be highly persuasive, right? Now, having finished with the first part of the issue on state sovereignty and state immunity, then we must discuss on the issue of immunity under international law. I have discussed and highlighted on immunity under international law when it comes to state, right? When it comes to state itself, right? As parties to disputes at the international level. Now we are talking about immunity of international law when we talk about individuals, right? Because at the international level, individuals also have immunity. The same goes to states under international law, under the same principle of par imparem non habet imperium. Okay. Now, before the end of or before the outbreak of the First World War, the ruler or the head of state, the king, right, or the president of a state, is the same with the state itself, right, and will be considered the same. If you are talking about the king, if you are talking about the queen, if you are talking about the president of the state, you are talking about the state itself, right? So they shall be treated the same, right? And if they are all the same, then they enjoy absolute immunity and sovereign immunity, the same that we have discussed earlier. That is why when we watch movies, for example, the old movies, all right, when wars have taken place, the parties must go to the palace, must find the king, all right, or must kill the king, or must arrest or must capture the king, because once the king or once the queen has been killed or has been captured, meaning to say that they have won and they have taken control over the whole state. Right? This is the principle, right? On par imparem non habet imperium. Okay. So it reflects, because when we talk about head of state, we talk about the state itself. So the principle of par imparem non habet imperium will be applied. Okay. So it reflects the same principle where the head of state cannot be sued or cannot be charged before foreign courts, right? For example, the head of state of Malaysia cannot be sued and cannot be charged for whatever crimes in Indonesia, because to charge and to sue the head of state is the same with charging and prosecuting or suing the state itself, suing Malaysia itself, because we have seen the case of jurisdictional immunities between Italy and Germany just now, the same principle, okay? However, after the end of First World War and the Second World War, this immunity is no longer applicable, all right? From sovereign immunity, then international law has split two types of immunity, okay? Because many heads of state during the First and Second World War have been using this immunity to commit international crimes, right? If immunity to be applied, right, even until now, then we will see many dictators, many heads of states to commit international crimes, and they cannot be prosecuted before any courts whatsoever for any crimes that these heads of state have committed, right? So that is why international law has split two types of immunity under international law after the outbreak of First World War, so that heads of state who have committed crimes at the international level will face criminal charges before competent tribunals. So customary international law has split two types of immunity. One called immunity ratione personae, right? In Latin, or in English we call it personal or private immunity. Second, immunity ratione materiae, right, or official immunity. So I will explain what are these two immunities under international law. Okay. Now, this immunity ratione personae and ratione materiae were crystallized and have been codified into a treaty called Vienna Convention on Diplomatic Relations 1961, and this convention has been ratified and exceeded by almost all UN member states. Now, just now I mentioned that we have 193 states of the UN member. So out of all these, only one state has yet to become party. So all 192 have become parties to the Vienna Convention on Diplomatic Relations, or the VCDR. Now, under the VCDR, two main provisions which talk about immunity under international law, particularly Articles 29 and also 31. Now, these two provisions mention that the diplomats, or ambassadors, or duta, ambassadors or diplomats, together with the staffs, together with their family members, shall be inviolable, right? Shall be protected at all times, and they shall not be subject to any arrest, right? If they kill someone, they cannot be arrested. If they knock someone while driving, they cannot be arrested. They enjoy absolute immunity from any criminal prosecution. So this was this provision has been inserted, and it has been practiced and applied by all states in the world, because this is customary international law. Right now, the ICJ in two cases, in the arrest warrant case, right, between Democratic Republic of Congo and Belgium, and in the case of mutual assistance in criminal matters case between Djibouti and France, the ICJ in two cases upheld the principle of inviolability of the diplomats and ambassadors. And these two cases of the ICJ mentioned that, right, because the VCDR mentioned about diplomats, all right? So the ICJ in these two cases mentioned that the immunity attached to the diplomats shall also be applied and shall also be extended to state high-ranking officials. Now, the question is, who are these state high-ranking officials under international law? So under international law, there are only three state high-ranking officials. Number one is the head of state, right? Ketua negara, the president or the king or the queen, okay? The head of government, right? Like Malaysia, the prime minister, the head of government, right? Like in Indonesia, the president, because the president is both the head of state and also the head of government. And third, the Minister of Foreign Affairs, right? So these three individuals are considered as heads of state under international law. So Articles 29 and 31 of the VCDR shall be applied to these three individuals as well. Okay. However, Article 32 of the VCDR mentioned that immunities attached to these heads of states, right, can be waived, can be removed at any time, but there are certain conditions, right? So I will explain what are the conditions so that immunity attached to these three individuals, the head of state, the head of government, and Minister of Foreign Affairs, can be waived at any time, right? Except for all these exceptions, then their immunities are absolute. You cannot deny their immunity under international law. Okay? I will explain to you on the example later on. Now, I will explain on the two types of immunity that I have mentioned earlier, ratione personae and ratione materiae. Now, what is ratione personae immunity? Now, ratione personae immunity applies to the sitting head of state. Now, why I use the word sitting head of state? It means that sitting head of state means that whosoever becomes the president, whosoever becomes the prime minister or the head of government, whosoever becomes the Minister of Foreign Affairs. Because like in Indonesia, the president will be or will hold office temporarily for up to 4 to 5 years term, and can only be extended if he or she won election for another term. So only within these within these terms, when he or she becomes the head of state, he or she becomes the sitting head of state in office. All right, he or she is the head of state. So when he or she becomes the head of state, either the president or the prime minister or the foreign minister, whenever he or she travels abroad, he goes to Kenya, goes to Saudi Arabia, goes to the US, goes to Mexico, any parts in the world, he or she will have this rationale personnel immunity. He or she cannot be arrested. He or she cannot be sued. He or she cannot be prosecuted for whatever crimes in any countries in the world, right? Even if he or she has committed torture or international crimes, genocide, torture, whatsoever. So this is immunity rationale personnel, which must be respected by all states in the world, because rationale personnel is a sovereign immunity, right? So because as sitting head of state, it reflects the state itself. If you are arresting, for example, Pak Jokowi, it is as if that you are arresting Indonesia itself. Then it violates par imparem non habet imperem principle, right? So this must be respected by all countries in the whole world. But head of state or sitting head of state will only hold office temporarily, let's say 5 years or 10 years, depending on the duration of the time period where he or she hold office. Okay. After he or she has no longer become the head of state or the prime minister or the sitting foreign minister, then he or she will no longer be protected by immunity rationale personnel, right? So rationale personnel immunity will go together with the tenure, right? Let's say the term of President Pak Jokowi, for example, would end 31st December. On 1st January, Pak Jokowi's immunity will no longer have immunity rationale personnel, right? So to make it simple, right? But upon the expiry of immunity rationale personnel, another immunity will take over, will replace immunity rationale personnel just now, called immunity rationale material. But this immunity rationale material has conditions, okay? The condition is that when the head of state, while he or she was being in office as the prime minister or as the president or as the foreign minister, when he or she has performed official acts, has done works which are official, all right, for the state, right? So he or she cannot be sued, cannot be arrested, cannot be charged for whatever crimes or whatever legal suits, even after he or she has retired or has no longer become the head of state. Okay, this was or has been decided by the ICJ in diplomatic and consular staff case between United States of America and Iran, right, where the ICJ mentioned that states are bound, all right, to protect the inviolability and immunity of the head of state, as long as he or she had acted or performed official acts while being in the office, right? Let's say that Pak Jokowi, for instance, or any president, while he or she as the president did the work as the president, right? Signed agreements between states, make contracts with another state, all right? Do trades with another state, all right? And everything or all actions are all clear, has no problems or violations of international law, then he or she will be protected by immunity rationing material even after he or she has retired and no longer becomes the head of state under international law. Now, the question is, how do we measure whether the acts, all right, performed or the conduct performed by the heads of state just now are official acts, right? The answer is we must measure the acts or conducts of the heads of state based on case-by-case basis. We have to look at the facts of the case, right? Depending on the case. I would like to highlight some of the examples, all right, where courts have decided in favor and also against immunity, right? When the head of state has retired, right? For example, in the case of Pinochet, right? So Pinochet was the army general and also president of Chile, okay? Between 1973 and also 1990. So throughout these years, Augustus Pinochet or General Pinochet had ruled Chile dictatorship, right? And during this tenure as heads of state, as the head of state of Chile, he had committed torture. Many Chileans had been tortured, right, by Augustus Pinochet and also by his subordinates. Okay, so on 10 October 1998, 8 years after he had no longer become the president of Chile, the Spanish court issued an international arrest warrant against him to arrest him and to charge him for committing torture. Okay, after he had retired from being a president of Chile. So when he traveled to the UK at that time, right, because of the arrest warrant issued by the Spanish court, the authorities in the UK knew that Pinochet would come to the UK, would come to London. When Pinochet arrived in London, right, the authorities in the UK arrested him because of the arrest warrant issued by the Spanish court on international arrest warrant just now. So when he was arrested in London, UK, he argued that he has immunity under international law. He cannot be arrested. Okay, so he argued that even though that he is no longer the president of Chile at that time, he has immunity rationing material. Okay, so the case was brought up to the House of Lords in England, right, in the UK, right, like in Malaysia and Indonesia, House of Lords is the same with the Supreme Court. In Malaysia is the Federal Court. Okay, so the House of Lords in the UK decided that Pinochet has no immunity rationing material. Why? Because the House of Lords decided that torture is not an official act of a president, right? So because torture is an international crime and is not an official act for a president, then General Pinochet will not be protected under immunity rationing material, right? And as such, he shall be extradited and to be arrested and sent to Spain for the trial. Okay. However, he died, right, during the proceedings, before the decisions to be made by the court, right? But although he was not convicted, but again, immunity rationing material in this case, you know, on the act of torture was decided by the court as outside official duty. Okay, it's not an official duty as the head of state. And many cases before the international tribunals or international courts where immunity rationing personnel and rationing material have been set aside, right? Ranging from the courts established after the First World War and also after the Second World War, before the Nuremberg Tribunal, before the Far East Tribunal for against the Japanese Empire, in the case of former Yugoslavia and also for Rwanda. So I do not want to dwell on that particular discussions. Okay? Now, just now I have mentioned that there are exceptions, all right, under international law, where immunity rational personnel and rational material can be set aside, right? Now, what are the situations, right? The conditions or the exceptions have been highlighted by the ICJ in 2002 in the case of arrest warrant case. So this the arrest warrant case was the case concerning the arrest warrant of 11 April 2002 between the Democratic Republic of Congo, or the DRC, and Belgium. Now, I would like to explain what happened in this case. Now, in this case was the court in Belgium issued an international arrest warrant. The same goes to Spanish court just now, right, where an arrest warrant was issued against General Pinochet. In this case, an international arrest warrant was issued against. Sorry. So an international arrest warrant was issued against Abdoulaye Yerodia and Dambossi. So Abdoulaye Yerodia and Dambossi was the sitting Minister of Foreign Affairs of the DRC, right? So at that time, when an international arrest warrant was issued by Belgium, Yerodia was the sitting Minister of Foreign Affairs, right? Now, the reason why Belgium issued an international arrest warrant against Yerodia was that Yerodia had incited, right, in his speech that genocide must and should be committed in the DRC, and the crime really took place, and genocide had taken place in the DRC after his speech. So Belgium took an initiative under universal jurisdiction to arrest Yerodia and to prosecute Yerodia for committing genocide. Okay. Now, in this case, the DRC challenged the arrest warrant issued by Belgium, right, against Yerodia before the ICJ. So both the DRC and Belgium agreed the case to be settled by the ICJ, right? So the DRC argued that Belgium had breached customary international law for upholding and respecting Yerodia's immunity under international law, because Yerodia is still the sitting head of state of the DRC. Now, even he had made a speech on genocide, and actually genocide had taken place, but this customary international law immunity must be respected because Yerodia was the sitting head of state. So the ICJ held that Yerodia immunity shall be inviolable, must be respected, right? Yerodia had immunity, right? Out of all these decisions, the ICJ mentioned that there will be only 4 exceptions or 4 situations where immunity of heads of state, either the president or the prime minister or the foreign minister, shall be set aside, right? Shall be removed under international law. So what are these situations? Number 1, immunity under international law shall be removed, all right, if the head of state had committed international crimes. Number 1, if the head of state itself or himself or herself to be tried before his or her own domestic court, right? For example, if the DRC decided to arrest him, to prosecute him in the DRC's court, right? So because that would not violate any international law. Okay. Number 2, if the state decided to waive the head of state immunity. Okay. So if the DRC decided that Yerodia immunity shall be waived, he is no longer the foreign minister of the DRC, only then, you know, he shall be prosecuted, or he can be prosecuted and arrested. Third situation, if the head of state ceases his or her office, only upon the expiry of the date of the office of the head of state, right? If he or she is still in office, then his immunity shall be protected. Okay. Lastly, if the head of state is tried before competent international courts, right? As I have highlighted earlier, states and states are equal. All right, so disputes between states can only be settled by a body or organization, right? A court which is higher than a state, right? Only an organization or a tribunal which is higher than a state, and international courts can only decide on state disputes, right? Or can decide on state fate. Okay, the same goes to here in this case, because the foreign minister, the sitting foreign minister is also the state itself. So only a body which is higher than the state can decide. All right. So only within these 4 situations where sitting heads of states immunity can be removed under international law for committing international crimes. If the situations of facts have not fall under any of these 4 categories, then immunity under international law must be respected. Okay? Now we have seen many heads of states have been decided or have been removed by a number of international tribunals where heads of states have been prosecuted and found guilty for committing international crimes right after the end of the First and Second World War. So these are some examples of the tribunals where the tribunals have removed immunity under international law accorded to the heads of state, because international tribunal has jurisdiction over the heads of state, because only international tribunals can decide on the fate of the heads of state, right? So like after the Second World War, right, when Adolf Hitler committed suicide, then Admiral Dönitz took position as the head of state of Germany at that time, and he was found guilty by the International Military Tribunal in Nuremberg for committing crime of aggression and other war crimes and crime against humanity, right? And the same goes to the Second World War Tribunal in Tokyo, all right? Instead of prosecuting Emperor Hirohito, many prime ministers of the Japanese empires and also many ministers, including foreign affairs ministers at that time, have been found guilty by the tribunal for waging wars right, against many countries, including the Philippines and many parts in Asia during the Second World War. The same goes to the tribunals established by the Security Council in the former Yugoslavia, right, for war crimes, genocide, and also crime against humanity, where the tribunal in the former Yugoslavia, or known as the ICTY, found 2 heads of state, right, guilty for committing international crimes. One is Slobodan Milosevic. He was the president of the former Yugoslavia, right? And also President Milan Milutinovic. He was the incumbent Serbian head of state after the Serbia got independence or ceased from the former Yugoslavia. Right? In Rwanda also, a number of state officials, including the Prime Minister of Rwanda, have been found guilty for committing international crimes, right? Where hundreds of thousands of Tutsis and Hutus were killed, right, in Rwanda. And you may Google on this issue, where, you know, if you look on the screen, many Tutsis and Hutus have been killed openly, right, in stadium, in schools, in public areas, right? So this is where Rwanda is located, right? If you wonder where is Rwanda is located, it's not Wakanda, it's Rwanda. So the tribunal, or the International Criminal Tribunal for Rwanda, decided that the Prime Minister of Rwanda at that time, Prime Minister Sean Kambanda, was found guilty for committing genocide, right? So Prime Minister Sean Kambanda was the first Prime Minister which was found guilty by the International Tribunal for committing genocide so far. He was the first. Okay? It's not a good record, actually, right? In other parts of the world, many presidents and former presidents have been found guilty as well for committing international crimes, such as President Charles Taylor for committing crime against humanity, right, in Sierra Leone and Liberia, and also former Prime Minister Q Sampan, all right, the former Prime Minister of Khmer Rouge or Cambodia during Khmer Rouge regime between 1994 or 1974 until 1979, right? And also a number of individuals to be prosecuted before the tribunal in Timor-Leste, right? Established between the UN and also the state government. Yeah. Those are the ad hoc tribunals or temporary tribunals. Now we have Permanent International Criminal Court, which is located in The Hague. So the ICC, or the International Criminal Court, has 4 jurisdictions. One is on genocide, second is on crime against humanity, third is on war crimes, and lastly on the crime of aggression. Okay, so before the ICC, a number of heads of state have been prosecuted and have been found guilty by the ICC, right? And these heads of state are still sitting heads of state, right? Such as President Omar al-Bashir of Sudan, President Muammar Gaddafi of Libya, President Laurent Gbagbo of Ivory Coast or Cote d'Ivoire, and also lastly, President Uhuru Kenyatta from Kenya. So these are all the presidents and the heads of state of their respective countries, which have been prosecuted and to be charged for committing international crimes of genocide, war crimes, and crime against humanity under the ICC jurisdiction. Right? I will talk about the prosecution of those crimes before the ICC and relate with the issue of state cooperation, which comes to the end or to the last part of my presentation. Now, when we talk about dispute settlements, whatever decisions to be decided by the court, especially by the ICJ, must be implemented by states, right? And these decisions, when states have agreed to bring the matters to the ICJ, for instance, then whatever decisions to be decided by the ICJ will be binding and will be implemented and must be implemented by states, right? So in this sense, state must cooperate with the ICJ, right? To enforce and implement whatever decisions made and given by the ICJ. Why? Because they themselves agreed to submit the dispute to the ICJ in the first place, right? So again, when we talk about the ICJ, these are all based on non-criminal cases, right? But when it comes to international criminal cases, where states are not parties to the case, but individuals, right, to be prosecuted. Now, when we talk about international criminal prosecutions, many states have been seen to be reluctant. They refuse to cooperate with the International Tribunal, especially by the International Criminal Court, right? Now, in what sense that states are refused to cooperate with the court, right? We have to understand that at the international level, right, before that, when a prosecution or investigation to be executed by the International Criminal Court, for instance, the suspect must be arrested, the suspect must be surrendered to the ICC so that the ICC to investigate and to prosecute the suspects before the court, right? Without the appearance of the suspect before the court, then the suspect cannot be prosecuted, right? Cannot be charged, right? This is a principle under international law, which has been highlighted under the ICCPR, an international convention, where an individual cannot be charged in absentia, right? Without his absence, he or she cannot be charged. Why? Because he or she must have the ability and must have the right to defend himself or herself before any court of law under international law. Now, when we talk about the arrest and surrender of the suspect, like it or not, we have to look at the historical record, right? Whether, all right, a suspect all right, has surrendered themselves, or and authorities of another countries went to another countries, arrested him or arrested her, and surrendered him or her to the court, right? Because at the international level, there is no international police, right? So there is no international police like we have peacekeepings, right? Because we have international military peacekeepings, right? But we do not have at the international level international police, where this international police to go to any countries to arrest the suspect and surrender the suspect to the international court. There is no such thing at the international level, right? So one leading case on this matter, on the arrest and surrender of a suspect for a prosecution before a national court, must be discussed by all undergraduate students, right? The case was the Eichmann case, right? So what happened in this case was Adolf Eichmann was a Nazi officer, and he was responsible for the war crimes and crime against humanity committed against the Jewish people during the Second World War, right? So he was the one who commanded, all right, and was responsible for the crime called Final Solution, to exterminate, to kill hundreds of thousands, even millions of the Jewish people, right, in a camp, right, called Terezin and Bergen-Belsen, right, in Hungary. So he was the one who was responsible for that. So when the Jewish people have been exterminated, have been killed, genocide have been conducted, right, and the Second World War had finished or had ended, he ran away and take refuge in Argentina. He was hiding in Argentina, right? So when the state of Israel was established in 1948, right? So Mossad was established. Mossad was the same with the CIA, right? In Israel, we call Mossad, or known as the Israeli Intelligence Service, Mossad. Mossad was instructed by the Israeli government to go to Argentina to find Adolf Eichmann, to abduct him, to kidnap him, and to bring him back to Israel to stand trials before the courts in Israel for committing genocide and crime against humanity during the Second World War. And remember, I have explained to all of you just now that states are equal under international law. For example, in this case, Israel and Argentina are equal before international law, and there is no international police. So the authorities in Israel cannot go into Argentina, do whatever he wants or they want, arrest and surrender the suspect and bring him or her back to Israel. This is a violation of international law. But what happened in this case was otherwise. When Mossad was instructed by the Israeli government to go to Argentina to kidnap Eichmann, and it happened, right? So Mossad people went to Argentina and abducted Eichmann and brought him back to Israel to stand trials, and it really happened. Now, the case was heard before the court in Jerusalem and has been appealed to the Israeli Supreme Court that Israel had violated Argentina's state sovereignty, right? Because Mossad went into Argentina, abducted Adolf Eichmann, and brought him back to Israel. This is a violation of international law. That was the charge and also the claim against the Israeli government, right? So these are the two issues brought before the Israeli courts. Now the courts in Israel decided that it has jurisdiction, right, to hear and determine Eichmann's case, and also to punish Eichmann, because whatever that he had done or he did during the Second World War to torture and to exterminate the Jewish people are considered as international crimes, And at that time, there was no international courts, right? As such, Israel to exercise universal jurisdiction, all right, on the basis that the victims were the Jewish people, right, which linked to the Jewish state of Israel, and it is vital for the state of Israel to protect its citizens, right? So that was a decision, and the case was appealed to the Israeli Supreme Court, and the Israeli Supreme Court upheld the Israeli District Court of Jerusalem that the abduction was valid under international law. And this decision has been criticized even until today on the violation of Argentina's state immunity under international law, where Mossad went to Argentina and abduct and do whatever they want in Argentina and bring the suspect to Israel. So this is a violation of international law, right? And for any of you who would like to know more about the case, there is a movie on Netflix, right, called Operation Finale, right, which reflect the case of Adolf Eichmann, which I have explained earlier. You can watch this movie, right? I'm not promoting any movie, and I'm not an agent of Netflix, but I have watched this movie before. So it's a good movie, so that whatever that I have explained earlier, so that you could, you know, relate and reflect, right, in the movie, right? So please watch Operation Finale on the case of Eichmann just now, right? Now, on the part of the International Criminal Court, or the ICC actually relies heavily on state cooperation because there is no international police, as I have mentioned earlier. All right, so states, especially state parties to the Rome Statute, which establishes the ICC, must cooperate with the ICC to arrest and surrender the suspect, right? Right, so the ICC will exercise jurisdiction if national authorities are unable, or if the national authorities are unwilling to investigate or prosecute the suspect. Only then the ICC will exercise jurisdiction, right? So when the ICC to exercise jurisdiction, then the suspect must be arrested and must be surrendered to the ICC, right? So because there is no international police, then the ICC must ask states to arrest the suspect, right? But states have been seen to be reluctant to refuse the court's application for cooperation, right? Now, as we all know that when states have become parties to any treaty, states must fulfill their respective obligations arising out of the treaty. Now, under the Rome Statute, particularly under Part 9 of the Rome Statute, it talks about obligation to cooperate with the ICC. So any state parties must cooperate with the ICC, okay? And any states which are not parties to the ICC, if the Security Council has referred the case to the ICC, then all UN member states must fulfill whatever decisions made by the Security Council, acting under Chapter 7 of the Security Council. I will relate with these later on. Now, for instance, the Security Council has referred the situation in Sudan, right, to the ICC under Article 13, Clause B of the Rome Statute, right, pursuant to Security Council Resolution 1593 on 31st March 2005, right, acting under Chapter 7 of the UN Charter. So when the Security Council referred the case in Sudan under Chapter 7 of the UN Charter to the ICC, whatever requests made by the Security Council and the ICC will be binding upon the courts, or upon the states in the world. Okay. Now, what happened in this case was 2 arrest warrants have been issued by the ICC, right, against the president of Sudan, right, President Omar al-Bashir, for committing genocide, war crimes, and crime against humanity, right? So these arrest warrants, right, must be enforced by all UN member states and also all Rome Statute state parties, so that these states must cooperate to arrest and surrender him. Now, what happened? South Africa, all right, was to convene a summit, right? Before that, right, the African Union repeatedly requested the Security Council to stop the indictment against the president of Sudan, right? But the Security Council refused, right? But to proceed with the prosecution. So because of that, the African Union decided not to cooperate with the ICC, right? To execute the arrest warrant issued by the ICC against President Omar al-Bashir, right? So since then, since the African Union has decided not to cooperate with the ICC, the president of Sudan went to many countries, went to many African countries, such as to the Democratic Republic of Congo, to Kenya, and to South Africa, and he was never been arrested and surrendered to the ICC. Okay. Now, the case started when the president of Sudan went to South Africa to attend the African Union Summit in Johannesburg in 2015. So the High Court in South Africa issued a decision that the Sudanese president cannot leave South Africa and he must be arrested in South Africa. But the South African government decided not to follow the High Court's decision and let him fled and ran away from South Africa by plane, right? So the Sudanese president was not arrested, right? Why? Because South Africa argued that South Africa cannot arrest the Sudanese president because he has immunity under international law. That's number one. Number two, as the host country, under Article 8 of the host agreement, South Africa and the African Union must accord and must respect all incumbent head of state with immunity. Because of this, South African government refused to follow the decision of the High Court in South Africa to arrest the Sudanese president. So because of this, he fled South Africa and was not arrested, right? So the parties, right, the interested parties in South Africa appealed the case to the Court of Appeal in South Africa that the government of South Africa had violated its obligation under the treaty. So the Court of Appeal in South Africa decided that South Africa was actually had violated its obligation to cooperate with the ICC to arrest the Sudanese president, right? So not only that, the ICC also held that South Africa and also the Democratic Republic of Congo and Kenya for violating their respective treaty obligation to arrest and surrender the Sudanese president to the ICC and breach their cooperation with the ICC. So these are among the decisions made by the ICC on the non-compliance by the South Africa, Democratic Republic of Congo, and Kenya on the refusal of these countries to cooperate with the ICC to arrest the Sudanese president. Right? So as a conclusion for my presentation, although there are venues, right, or mechanisms, right, for states and individuals to settle their disputes at the international level, right, but still the issue of state sovereignty, right, or sovereign immunity, right, immunity to the heads of state and also state cooperation have become issues and hinder settlement of disputes between states and individuals at the international level, right? So with these problems, right? So the spirit of Article 2, Clause 4 of the UN Charter, that state must settle their disputes by peaceful means, cannot be easily fulfilled by all the countries in the world, right? So in order for countries or for states to fulfill their obligations or to settle their disputes peacefully under international law, right? so that disputes between states and among individuals at the international level would be settled. It requires states' political will. States themselves must have their political will to enforce and to cooperate and to enforce whatever decisions and cooperations requests made by any international competent tribunals, and also to enforce their respective obligations under any treaty, so that the spirit of Article 2, Clause 4 of the UN Charter to be fulfilled. Right. So with that, I thank you, and I open to everyone any questions, and I will try my best to answer those queries. So with that, I thank you.
Okay, thank you very much, Dr. Fard, for your presentation. It's very nice presentation. And I have some notes here about international dispute settlement. First, there are requirements and issues on dispute settlements. First, state sovereignty, second, immunity, and third, state cooperation. And then the errors dispute settlement arbitration had long been practiced, evolved as a sophisticated procedure, similar to judicial settlement. And you have talked about Alabama claims arbitration case of 1872 between the US and Great Britain, UK. And about the World War I and II, and about the Permanent Court of International Justice, PCIG, and about International Court of Justice, or ICJ. And you have talked about the differences between case on immunity before national courts and cases on immunity before international courts. So, and there is no international police. And then about the state cooperation. And right now, we are going to the Q&A session, and I see there is Miss Dr. Bu Wartini, Bu Sri Wartini. You have raised hand, and you can unmute your microphone, Bu Wartini.
Okay, thank you.
And you can directly ask to Dr. Farid. Okay.
Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
It
was very fantastic presentation and very detailed, so that your PPT can be used for one semester. Okay. Yes, I appreciate it about your presentation. I have two questions that I would like to propose. First question is related to the ICJ jurisdiction. That's when state would like to bring the case before the court, so that it must be there is the consent, okay, there is the consent of other parties. So in the absence of the consent of other parties, there will be no process in the ICT. So how to solve this problem? Sometimes that state would like to have such kind of argument that they don't want to settle dispute into ICT, even though that the other parties would like to bring the case before ICT. And what is happening in Indonesia and Malaysia in the case of Sepadan Likitan, because there is the consent, so that Indonesia lose the case at that time. So what kind of aspect that sometimes that doesn't want to settle the case before ICJ? Is it because that there are some reason with there is no feasibility of the state itself if use the mechanism in the ICJ, or is there any political reason? And second question is related to South Africa, non-compliance of South Africa. Actually, it's based on the universal jurisdiction that a state has some kind of jurisdiction, even though that the crime itself is not in their jurisdiction, or the victim is not in their jurisdiction. It's like in the Pinochet case, when Pinochet has already retired, and Pinochet would like to have some kind of medicine treatment in London, so that British government also arrests Pinochet. However, that's finally that Pinochet also released and go back to his state in Chile, and in Chile itself, even though there is the decision, but the decision actually is not so hard decision, because it's only in that Pinochet only can stay at home and so on. So actually that's international law can force this kind of universal jurisdiction And related to the case of the South Africa, so is there any sanction actually which can be applied to South Africa when South Africa not comply with the ICC rule or the Rome Statute? Okay, thank you very much.
Okay, thank you very much. Yeah, Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Bu Sri Wartini. You have two questions. Okay, Mr. Farid, you can answer it directly.
All right. Thank you, Dr. Sriwarti, for these two very wonderful and mind-boggling questions. Now, she asked on the ICJ jurisdiction where states must consent to bring the case to the ICJ. So the answer is yes. Now, why? Because we have to understand that if states did not consent to bring the case to any dispute settlement mechanisms, arbitration, mediations whatsoever, then whatever decisions cannot be enforced, right? So it goes back to the root of political will of any states. Now, when we talk about political will of a state, we are talking about the current government at that time, all right? Because the government of the day, whether the government of the day has the will or would have consented to bring the case to the dispute settlement mechanism, such as the ICJ arbitration and so on, or not. Now, perhaps that, for example, disputes between country A and B, the government the government of the day of country A and country B, let's say, at that time decided not to bring the case to the ICJ, for example. But we have to understand, political parties who won the election will come and go, right? Let's say party A won the election at the time. Next election, that party would lose the election. Then new government will be formed. So when new government will be formed, perhaps that they have different perspective on the issue. Perhaps that when they have formed new government, they would bring the case. They would have agreed to bring the case to the ICJ, all right, as compared to the previous government. Okay, so that is why I mentioned that all this, right, when we talk about state cooperations, right, whether to bring the case or not to the ICJ, we need to have political will. And this political will have to look at the government of the day, right? It's like us. Let's say today we get angry with someone. When we go to sleep, when we wake up in the morning, then our anger will loosen up, and perhaps that we will be friendly with that particular person that we have been angry of before, right? So it depends on what was the mood of the government at the time. All right. So that perhaps that I've addressed your first question, Dr. Sriwartini.
Yes,
and on the second question on the issue of universal jurisdiction, right, particularly on the Commission of International Crimes. Now again, universal jurisdiction can be exercised by any countries in the world if international crimes have been committed. But this universal jurisdiction is still subject to other customary international law principles, such as immunity under international law. If the suspect to be arrested and to be prosecuted, all right, for committing international crimes, and the country which is interested to exercise universal jurisdiction, that particular country must respect other customary international rules, i.e. immunity, whether the suspect has immunity or not under international law. If the suspect has no immunity, then the country can exercise jurisdiction without any problem. But the question arises when the suspect to be arrested and to be prosecuted under universal jurisdiction, if he or she is still sitting heads of state, for instance, then the country must respect immunity accorded under customary international law to that particular suspect, right? This has been seen in many occasions. For example, in the case of Eurodia, right? Even if Eurodia has committed, had incited genocide, the ICJ itself has decided that since Eurodia is still the sitting head of state of the DRC, then Belgium must respect Eurodia's immunity under international law, even if Belgium is trying to exercise universal jurisdiction against Eurodia, right? But it doesn't mean that Eurodia has immunity forever, all right? The ICJ has mentioned the 4 exceptions. Until and unless, right, the DRC decided to withdraw immunity given to Eurodia, which was not the case. Second, until the DRC national authorities was the one to prosecute Eurodia, which was not the case. Thirdly, until Eurodia ceases his office, right? So Belgium, if Belgium to exercise jurisdiction against Eurodia, Belgium must wait until Eurodia ceases his office as foreign minister of the DRC. If all these conditions under international law has not been fulfilled, then customary rules on immunity must be respected. Although universal jurisdiction is also form part of customary international law, because you cannot pick and choose which customary international law for you to implement. So all rules under customary international law must be observed at the same time. I hope that I have addressed your questions.
Thank you very much, Doctor.
Sure.
Okay, thank you very much, Dr. Fad, for your answer. And now we have a question from Prof. Tri Prihatina in chat room. The basis for the attack to Iraq LED by the US George Bush II was the production of weapons of mass destruction. And up to now, this has not been proven. How is the analysis from the legal aspect why the US and allies are not brought to justice where the losers are clear and hooked, including civilians? Okay, what is the answer, Dr. Farid?
All right, it's a good question. Now, the attacks by the US against Iraq, right? So we have to understand the nature of the courts, or especially the ICC jurisdiction, number one, and whether it falls under the ICC jurisdiction or not. Now, the attacks by the US-led allies against Iraq at the time, right, took place in the early 2000s, right? Now, the ICC commenced its jurisdiction from 1st July 2002. That was the starting point where the ICC can exercise jurisdiction. Now, until today, the US is not a state party to the Rome Statute, which establishes the ICC, right? Iraq also, at the time when the crime or when the attack took place, Iraq also was not a state party to the ICC. So both Iraq and the US are non-parties to the Rome Statute, which establishes the ICC. Okay, so generally the ICC cannot exercise jurisdiction, right? But another alternative is that, right, the Security Council may bring the case or may refer the case to the ICC under Article 13B of the Rome Statute. Now, another problem arises is that the US is one of the permanent members to the Security Council. Any decisions or any resolutions to be adopted by the Security Council must receive no veto from any of the 5 permanent members of the Security Council. And if the Security Council to pass a resolution to bring the case of the attack, let's say, by the US-led against Iraq to the ICC, don't you think that the US would have vetoed the resolution, right? So if the US vetoed the resolution, then the decision cannot be enforced, and the ICC cannot exercise jurisdiction at the end of the day, right? So these are all the problems under international law. And it goes back to my point that it all based on political will. if the US willingly to bring justice, right, to settle the disputes, for example, then the US would willingly agree to the referral to the ICC if the ICC can exercise jurisdiction or not, right? But of course, the US has no political will, because at the end of the day, its own former presidents would be prosecuted before the ICC, and this will tarnish the US reputation at the international level. And the US will be, if the court decided that the US was guilty, especially Bush was guilty for the commission of the attacks against Iraq at that time, then the US will be called as war criminals by the international community, right? Because it was decided by the court. So this, at the end of the day, goes back to the root on political will. Hope that I have answered three Prihatina's questions earlier.
Okay, thank you very much, Dr. Farid. And next question from Ms. Aryuni. Bu Aryuni will give you a question. Ms. Aryuni, you can unmute your microphone. Okay, please.
Okay, thank you. As we know, based on Article 5 from Statute, there are 4 crimes within the jurisdiction of ICC: war crime, genocide, crimes against humanity, and crimes of aggression. But in current development, since 2016, there is a movement of activists and jurists are seeking to make crime of ecocide within jurisdiction of ICC. They propose a crime of ecocide as 5th jurisdiction of ICC. Okay, Dr. Farid, I have a question. Is necessary criminalizing ecocide under Rome statutes? What's your opinion about this issue? And the second, is possible make crime of ecocide within the jurisdiction of ICC? Thank you.
All right, thank you. It's a good question. Now, to add or to remove any crimes under the ICC jurisdiction will be decided by the assembly of the state parties to the Rome Statute. Okay, so the assembly of state parties to the Rome Statute is like the DPR in Indonesia, and it's like the parliament in Malaysia. Only the assembly of the state parties can decide whether new crimes to be inserted or the existing crimes to be deleted. Okay, so if the assembly of the state parties to the Rome Statute decided that ecocide, right, shall be recognized as one of the crimes under the ICC jurisdiction, then Article 5 shall be amended and new provisions will be inserted under any provisions of the Rome Statute so that it criminalizes ecocide as one of the crimes under the ICC jurisdiction. But as rightly mentioned by Dr. Aryuni, that since 2016, there have been movement to criminalize ecocide. But now this is already 2022. 6 years have passed. So it shows that state party assembly of state parties in 6 years time have yet to come into conclusion and have yet to agree to amend the Rome Statute to criminalize the ecocide and to insert ecocide as one of the crimes under the ICC jurisdiction, right? But this is still on the existing political will of state parties within this 6 years time. We do not know whether next year, next month, or in few years' time, that the political will of the state parties to the Rome Statute, which form part of the assembly of the state parties, they agreed and decided that ecocide should be inserted as one of the crimes, right? So if you ask me whether I agree or not, then we have to understand whatever crimes to be inserted under the ICC jurisdiction, it goes back to the root. Number one, cooperation, right? Political will. Number two, if ecocide, let's say, has been amended and has been criminalized under the Rome Statute and has been one of the crimes under the ICC jurisdiction, the question is whether the suspect can be arrested and surrendered to the ICC or not, right? So that whosoever had committed ecocide would be punished by the ICC. We have seen so far that states have been refused to cooperate with the ICC. So the root problems or issues, right, must be settled first, right, before whatever crimes to be added or to be removed from the Rome Statute. So I hope that I have addressed Dr. Ayuni's question.
Thank you, Doctor.
Sure.
Okay, thank you very much, Dr. Farid. And now, question from the students. I see there are students from University Sultan Zainal Abidin, University of Malaysia, and student from Faculty of Law, General University. You can raise hand, or you can, raise hand and unmute your microphone directly, or you can write the question in chat room. Come on.
Yes, yes. Please take this opportunity to ask questions.
Because I see from Brunei Darussalam. Is it your student, sir?
Yes, I taught some students from Brunei before. So perhaps that they are my former students or the new students.
Okay, great. Come on, students from Faculty of Law and Sharia from UMUM or from General University or from Brunei. Come on. You can raise hand and unmute your microphone.
Do not be afraid to ask questions. You will not be arrested and prosecuted for asking questions.
Okay. Okay. There is no questions. Come on, guys.
Come on. Or you want to ask me via my social medias? Perhaps that you're shy to ask questions in front of these mass numbers of audiences.
Okay, Dr. Farid, what do you think about the international dispute between Israel and Palestine? So, okay. Before my answer, there is question from Mas Aji Stiadi. Yeah. Okay. Good morning, Mas Aji. You can ask the Dr. Farid directly.
Mas Aji.
Okay, Mas Aji has right a question.
He's
okay.
driving.
Oh, he's driving. Okay. Is there any specific customary international law governing the diplomatic protection by state to protect the citizen of its state? Okay. Mas Aji said is alumni from Faculty of Law, and he is an international arbiter in Indonesia.
All right.
Okay, Dr. Yeah.
Okay, thank you for the question. Now, when we talk about protection of the citizen of its states, then we must question again whether these citizens of a state, let's say citizens of Indonesia or citizens of Malaysia, whether these citizens are heads of states or not. If these citizens are ordinary citizens, then under customary international law, ordinary citizens has or have no immunity. If ordinary citizens like you and me, we have immunity, then we can do whatever we want in any countries in the whole world. We can go and rape any individual. We can go and rob any banks in the whole world. We can go and knock someone else while driving in the whole world. Then no one's going to arrest us. No one's going to prosecute us in any court of law. So that is why international law only accord to certain individuals with immunity. Although certain individuals have been accorded with immunity under international law, but this immunity is still not absolute under international law. As I mentioned earlier, If 4 exceptions have been fulfilled, then immunity shall be removed, right? So to answer and to address your questions, not all citizens should be accorded with immunity, and there is no such rules under international to accord any immunity to any citizens, except if those citizens are the heads of state. Because the head of state, such as President Pak Jokowi, is also a citizen of Indonesia. If Pak Jokowi is not a citizen of Indonesia, he cannot become the president, right? But when a citizen becomes the president or becomes the head of state, he or she shall be protected under customary international law. So to address your concern, citizens should be accorded with immunity unless he or she becomes the troika or hold positions as the head of state. Or else then ordinary citizens such as you and me, we will not be protected. I'm afraid so, right? Thank you.
Thank you very much, Dr. Farid. And now, Mr. Hulki is a raising hand. Okay, Mr. Hulki, you can unmute your microphone and you can ask the Dr. Farid's directly.
Okay, thank you for the opportunities. Bu Sri Wahyuandayani. My name is Husnul Huluki. I'm currently now studying at Jenderal Sudirman University, taking Magister of Law or Master of Law. My question is, in your previous presentation, at the early pages, you said that one of the reasons why the United Nations was established is to prevent more wars in the future. But as we know, nowadays, there is what we call such tragedy between Palestine and Israel, and also Ukraine and Russia. What I want to know is what your opinion about it, and could this tragedy or this what's happening now between Palestine and Israel and also Ukraine and Russia could be brought into International Court of Justice? Thank you.
Okay, thank you very much.
Now, thank you for highlighting this question. So he asked whether the issue between Palestine and Israel and also Ukraine and Russia can be brought to the ICJ. Right? Now, we have to understand and look whether the so-called violations of international law have been done between Palestine and Israel, and also Russia and Ukraine, violated non-criminal matters or criminal matters. If it falls under non-criminal matters, then they can be brought before the ICJ. If it's crimes, war crimes or genocide or crime against humanity, then the ICC will exercise jurisdiction. Now let's analyze both ways, the ICJ and the ICC. Okay. Now, in relation to Palestine and Israel, as I mentioned to you earlier, whosoever member to the UN will automatically be a member to the ICJ. Okay, so until today, Palestine is not a UN member state. As such, Palestine is not a member to the ICJ statute, and as such, any disputes arising in Palestine or by Palestine or in has relation with Palestine cannot be brought to the ICJ because Palestine is not a UN member. When Palestine is not a member, then cannot bring the matter to the ICJ. So as such, the ICJ cannot settle disputes non-criminal matters between Israel and Palestine, period. Okay? Although Palestine agreed to bring the matter to the ICJ, but because of the non-membership of Palestine to the UN, then it cannot bring the case to the ICJ, right? Settle on that. Now, on the ICC, on the crimes, on the criminal parts between Palestine and Israel. Now, Israel, until now, is not a state party to the Rome Statute. Palestine only became party to the Rome Statute since 2015. Right? Under international law, we have learned on non-retroactivity principles, whereby crimes committed before the enforcement of the law cannot be enforced by the court. It means that whatever crimes committed against the Palestinians before Palestine became a state party in 2015 cannot fall under the ICC jurisdiction. It can only be done after the Palestine has become state party to the Rome Statute until today, right? So it cannot be applied backdatedly. Okay, that's point number one. Point number two. Now, one party, Israel, is not a state party to the Rome Statute. Second is Palestine is a state party to the Rome Statute. Now, to bring the case, all right, suspects must be arrested. Right now, before suspects to be arrested and to be prosecuted before the ICC, then the ICC must have jurisdiction. Okay, so since one party is a state party, another country is not a state party, then the only situation that can make the ICC has jurisdiction is by way of Security Council referral. Right, under Article 13, Clause B of the Rome Statute. And as we all know, that that Israel and the US have close relationship. Now, resolution must be passed by the Security Council so that the ICC to exercise jurisdiction. So if the Security Council to adopt any resolutions to refer the case or the situation between Israel and Palestine to the ICC, the US would veto those resolutions. Then Article 13B cannot be applied. Another alternative is that under Article 13A, right, where state itself refers the matter to the ICC. Right now, in this situation, it is highly unlikely that Israel to refer the case to the ICC. Right? Because if Israel agreed to refer the case to the ICC, then they would have agreed to put their neck on the guillotine. They would agree that whatever decisions to be made by the ICC will make their heads of state, their prime ministers or whatever generals will be responsible. That will be highly unlikely to happen. But then, I also had contributed to prepare a written submission to be submitted to the ICC so that the ICC to exercise jurisdiction. So the ICC in 2021, February last year, decided that the ICC has jurisdiction on the basis that on the proprio motu investigation to be conducted by the ICC prosecutor, because many reports have been made by many countries and NGOs all around the world to push the ICC to take action and to exercise jurisdiction, right? So now, last year, the ICC has decided that the ICC has jurisdiction. So the perpetrators must be arrested and must be surrendered to the ICC for investigation and prosecution. But again, it goes back to my early presentation. Political will to arrest and surrender the suspects. If the ICC issued arrest warrant against Ariel Sharon or whatever individuals in Israel, do you think that the Israeli authorities, would have agreed to arrest their former prime minister or whatever generals that they have to be surrendered and arrested and surrendered to the ICC? So another perspective of international law that must be settled. Okay, that is on Palestine and Ukraine. Palestine and Israel. On the part of Ukraine and Russia, right? For the ICJ, if you talk about the breach of use of force, breach of UN Charter, the case can be settled at the ICJ or before the ICJ. But the question is that both Ukraine and Russia must agree to bring the case to the ICJ. And do you think that Russia or Ukraine would have agreed? Ukraine might have agreed, but not Russia, right? So that ICJ to decide on whether any of them have violated their international obligations under international law. That is on the part of ICJ. On the part of the ICC, Russia is not a state party. Ukraine is a state party. The same goes to the issue between Palestine and Israel. So the only way is that the Security Council must refer the case to the ICC. That is one of the ways. So Russia is one of the permanent members in the Security Council. Any resolution to be adopted by the Security Council will be vetoed by Russia. Okay, so it seems like this is an endless problem. But again, it goes back to my presentation just now. It is up to political will. Perhaps that now the current president is Putin. Putin refused to bring any case to the ICJ or to the ICC. Perhaps that in the future, whosoever becomes the president of Russia, he or she decided to agree to bring the case to the ICJ or agree to proceed with the investigation before the ICC, for instance, then there will be another story. Until and unless that time comes, then this is the existing scenario that we have under international law. I hope that I have answered Kusun Hulokil's question.
Okay, thank you very much for the explanation, sir.
And I hope that I have addressed Dr. Sriwayu's questions also. She asked on Palestine and Ukraine's, Palestine and Israel questions earlier.
Yeah, last question about cases between Palestine and Israel. Okay, is there an ambition? There is international dispute settlement between Israel and Palestine, because there are requirement issues on dispute settlements as state sovereignty, immunity, and state cooperation. Okay, is it possibility for Israel and Palestine they can decide it like the case to international dispute settlement?
All right, yeah, it's a good question. Now, let's say we are talking about claiming damages or reparations, right? Claiming monetary compensations for the bombing of buildings and for the loss of whatever properties, let's say. Again, whether it will go to the ICJ or to the arbitration or to the mediation or to the reconciliation or whatever dispute settlement mechanisms, again, both Israel and Palestine must agree to bring the matter to all these dispute settlement mechanisms. If only one party agree, then there will be a problem, because whatever decisions to be made by whatever mechanisms to settle the disputes cannot be enforced, right? So it cannot be only one party, right? The same goes to crimes, because those other dispute settlement mechanisms cannot decide on criminal matters. The only way is that either to establish another international tribunals or the ICC to exercise jurisdiction. But again, the ICC already decided that it has jurisdiction. But the question here is that whether the suspects can be arrested and can be surrendered, right? Because these suspects these suspects cannot be investigated or tried in absentia. They must appear before the court so that they have the opportunity to defend themselves before the ICC, because that is one of the requirements and principles under the ICCPR, right? Because the ICCPR has make sure that trial in absentia is prohibited under international law.
Okay, thanks so much, Dr. Farid. Okay, and I will give you a chance to ask question. Okay, is there any question here from students again? Okay, any questions? Okay, before we close this presentation, please, Dr. Farid, to give closing statement.
Thank you. Thank you so much for the last opportunity for me to speak before all of you. Now, I would like to highlight on 2 points. Number one, on the gaining of knowledge on international law, and also the opportunity given to me. Now, perhaps that whatever that we learn, all right, at the university, right, in lecture theater, right, might have seemed not to be the same with the practice of international law, right? Because we need to keep up ourselves with the practice of the international law, with the international community, right? Because new decisions will be made by the courts, right? Let's say we only learn on the general rule, right, or on the law, but perhaps the new decisions have been decided by the court on the exception to the general rule, right? So the gaining of new knowledge, right, on international law spectrum must be advanced by all of us, right, including myself, right, because we must keep up, right? But we should not stop learning at lecture theater only. We must convey our opinion as well, write at least something on newspapers or whatever medium that we have, Twitter, Facebook, Instagram, whatsoever, so that we will be able to convey messages to the international community on whatever that we have learned so far. That's on one part. Second part is that I would like to take this opportunity to thank to Faculty of Law, General Sudirman University, for giving me this opportunity. So, because this is my second chance and second opportunity to teach and share my little knowledge on public international law with all the students and mahasiswa and mahasiswi at the Law Faculty of UNSUD this time around virtually. And I hope that should I be given another chance and another opportunity to share my knowledge with UNSUD students again in the future. So I hope that I could deliver lectures face to face, so that we would have a very interactive discussions and more discussions and more issues to be debated, right? Because I would love to have debate with my students when we talk about and when we talk about international law, particularly the current issues, right? So with that, I thank you.
Okay, thank you very much, Dr. Farid, for your closing statement. And before we close this session, I will, with the conclusion of your presentation. Okay, although there are venues to settle dispute between states and the punish the perpetrators of international crimes, the issue on state sovereignty, sovereign immunity accorded under SAIL, and states cooperation handle the settlement of these disputes. And with these problems, the spirit of Article 2 and number 3 of the UN Charter to settle international dispute by peaceful means, that international peace and security and justice are not endangered, cannot be easily fulfilled. Okay, and now thank you very much to Dr. Farid for the important materials to deepen our knowledge about the issues international dispute settlement. And I also thank you for this to the students from Malaysia and Brunei. Darussalam has been joining this general lecture. And now I give to the Miss Annie as master ceremony. And thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Farid Mohasan and Dr. Sri Wahyu Handayani for giving such an informative and comprehensive presentation, and also for bringing us to a very productive session today. And ladies and gentlemen, please allow me to show you certificates of appreciation given to Dr. Farid and Dr. Sri Wahyu Handayani, since they have imparted their valuable insights and inspiration for us.
Thank you so much for this wonderful certificate, and thank you to Faculty of Law, General Sudirman University for this certificate and opportunity.
Okay, thank you. Ladies and gentlemen, on behalf of the Faculty of Law Jenderal Sudirman University, we would like to say thank you for your active participation today and have a great rest of your day. I'm Eni Dijayani signing off. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much. And I hope that I can
Thank you so much,
still
Doctor.
keep in touch with all of you, Dr. Sriwayu and Dr. Annie, Dr. Sriwartini and all, right? And all the students
Thank you.
can still keep in touch.
Thank you, Dr.
Thank you very
Farid.
much, Dr. Farid. Nice to meet you.
Nice
And
to meet
we'll
you
hope
too.
we'll see you again in another general lecture. Maybe you can come to Indonesia and in the next year, or maybe.
Yeah, inshallah, inshallah.
Enjoy Yogyakarta, Doctor.
Yeah, inshallah, inshallah.
You can go to Mr. Sriwartini.
If you, I invite me to go and to at least share my little knowledge with the faculty, and I would be very honored to do so.
Okay, thank you.
Oke, terima kasih.
Terima kasih Ibu ya Ayu
Terima kasih
for
semuanya.
helping.
Thank you very much.
Helping
Terima kasih
semuanya yang sudah
so
hadir.
Semoga sehat selalu semuanya.
Yeah.
Terima kasih,
Amin.
Bupati.
And enjoy your weekend.
Okay, thank
Thank
you.
you.
All right. Thank
Mohon
you
pamit
all.
ya.
Yeah.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you.